Divisions are not based on jurisdiction, which means if you are arrested, your case will end up in front of any of the divisions that you are voting for. Judges are nonpartisan, elected officials, which means voters cannot rely on party lines to cast their ballot. Instead, voters need a nonpartisan understanding of their candidates, qualifications, and judicial philosophies. To help you with that, we're here tonight. I'm Bonnie Jean Feldkamp, the opinion editor for the Louisville Courier-Journal. I will be your moderator. 13 community partners came together to bring you this judicial candidate forum, and they are the Courier-Journal, the Louisville Bar Association, League of Women Voters, Legal Aid Society, the Louisville Alumni Chapter of Delta Sigma Theta Sorority, Inc., Charles W. Anderson Jr. Bar Association, the Main Street Association, Simmons College of Kentucky, the Jewish Community Relations Council, National Council of Jewish Women, Louisville Section, Louisville Urban League, Women Lawyers Association of Jefferson County, and our timekeepers tonight are brought to you by the Alpha Kappa Alpha Sorority Inc., the Eta Omega Chapter. Thank you so much for being here. And we're here both online and in person. If you missed our September 22nd forum that focused on the district court candidates, you can watch that on the Courier-Journal's website and YouTube channel. We will focus on Circuit Court, Court of Appeals, and the Kentucky Supreme Court this evening. So let's get started. There will be a one-time accommodation requested that we are honoring for Circuit Court Division 4. All other races will be called in sequential order. Each race is allotted a 13-minute long total segment. If a candidate could not attend in person, our policy is not to allow representatives or to accept statements. Each candidate is allowed to give a 1-minute introduction, and the remaining 11 minutes are reserved for questions. How concise your answers are will determine how many questions you receive. Our timekeepers are seated right here, and they will show you timing notifications. You'll get a 1-minute warning, a 30-second warning, and then a stop. So you'll know that each segment. So we will start this evening with Circuit Court Division 5. You can come on up to the table, and that would be Mary Shaw and Tracy Yvette Davis. Thank you. I'm going to walk around to the other side. I'm still with you. I'm always worried with the live stream that people are going to think we disappeared. Good evening. So we will go in alphabetical order as far as the introduction. So that means Tracy Davis, you will go first, and you have 1 minute to introduce yourself.
Okay. Good afternoon. My name is Attorney Tracy Yvette Davis, and I'm running for Circuit Court Judge here in Division 5. For the past 9 years, I've been in private practice in Louisville, Kentucky. That's where my office is located, but I practice throughout the entire state of Kentucky. I have practiced before the trial courts in District Court, Circuit Court, Family Court, as well as Federal Court. During this election process, I've received numerous endorsements. Those include a unanimous endorsement from Central Labor. I've received the endorsement of the UAW. I've received the endorsement of Teamsters 783 and 89, as well as Seafair. In addition to that, I also received the endorsement of L-Surge and many more. If you'd like to know more about me or about my campaign and my endorsements, you can go to www.votedavisforjudge.com. Thank you.
Thank you. Mary Shaw, 1 minute.
Okay. Well, my name is actually Judge Mary Shaw. I've been doing this for almost 16 years. I was born and raised here in Louisville, Kentucky. I went to the U of L Brandeis School of Law. My first job out of law school was as a staff attorney for circuit court judges. I was a trial commissioner for district court. I did that for like 16 and 11 years. I got elected to the bench in 2007. And since then, I have been the presiding judge in Division 5. For the last 14 and a half of those years, I have volunteered as a drug court judge and have done that. I was endorsed by the Citizens for Better Judges. I got a 92% rating in the Louisville poll here, the Bar Association poll, and I respectfully ask for your vote come this November. Thank you.
Thank you. So our first question, again, we'll start alphabetical order, and then the next question you will answer first. And the first question is, It has been suggested that prosecutors approve search warrants and that judge shopping should be eliminated when police seek search warrants. Do you support these reforms? Why or why not? And what other reforms are needed?
I do believe that reforms are definitely needed. I believe that when applying for a search warrant, that there should be some type of system. That way you're not able to form shop for a particular judge. I also, in addition to that, believe that if you go before one judge and that search warrant is denied, that whatever altercations that you make within that warrant, it should have to go back before that exact same judge. I do believe that there needs to be a lot more oversight. What I would do if it were me, I think that most search warrants should go on the record. I think that there should be a way for transparency to be done. And I think that we need to all come together with a communal effort in order to change that process. That's about all that I have to say about that at this point in time due to my race. Thank you.
Thank you. Judge Shaw.
I do support those reforms. Actually, I think that the best reform that anybody, they did a task force. I think the best reform that's come out of this is that prosecutors would look at the search warrants first. I know policemen, they're trained in what is probable cause, whatever, before they come to get a search warrant, but I think just an extra set of eyes on it would be a wonderful addition to it. I don't have any problem with putting any search warrant on the record. By law, all you can do is look at the affidavit that a policeman can stand before you and tell you anything he wants, but it's only the affidavit that you can use. But I have no problem with putting anything on the record or anything like that.
Thank you. Yeah. Our next question. How would you handle a situation in which a party in your courtroom was being poorly represented by an unprepared or ineffective attorney? Judge Shaw, you're first.
Thank goodness that does not happen very often. But in a few cases, you've got to talk with the person. If it's you can't interfere. If that's who they've chosen to have represent them, then there's nothing you can do. If what they're going to plead to or something like that, you can talk with the prosecutor, you can talk with the defense attorney, see if you can't come to a better agreement. If it is a PD that you've appointed them and they're not getting along, then you can have a hearing, and sometimes I've had to appoint other PDs when they're just conflicts with counsel. But I mean, it's something you have to address, but thank goodness it does not happen often.
Thank you.
Thank you.
Ms. Davis.
As a judge, it is not your position to interfere with regard to a case. I believe that if you see something that violates the rule of law or that violates ethics or something that you would in other arenas report something to the Bar Association, then it is your duty to address that issue and to do your due diligence in reporting something to the bar. However, it is not the judge's position to advocate for either party or either side. Poor representation, although we may see it very often, does not necessitate a judge interfering into litigation or into the judicial process. So I would think that for me, it would be whether or not there was a violation of ethics that was going on and someone was being severely harmed.
Thank you.
Thank you.
I'm going to request for speaking to the microphone just a little bit more so we can get the sound a bit better.
Absolutely.
Sure. Thank you. What methods do you have in mind for improving court procedures and efficiency? Ms. Davis, you'll go first.
Absolutely. Well, it's 2022. I do believe in technology, and I believe that we have realized since the pandemic that it is an increased level of accessibility to the courts and an ease to certain litigants before us when we use technology. One of the things that I think that I would do as far as circuit court judge would be to implement a program sort of like what they do in family court, which is make pre-rulings and allow the attorneys and the litigants to see what the pre-rulings would be based on just the information that has been provided through the pleadings. At that point in time, if there is an objection or if someone wants to be heard, then they should have the right to be able to be heard at that point in time. I think that that would keep down on time, and if someone needs to have a hearing or whatever the case may be, then you would be able to do that. In addition to that, I believe that litigants as well as attorneys should be able to appear before the court via Zoom. I think that that's more efficient than clogging the courtroom and dragging people in and out of the courts. I think that you can do things by making quick decisions, by e-filing some of your orders and things of that nature. But there's a lot that can be done to expedite the process within the judicial system and to not bog down the courts or the cost to the court system.
Thank you. Judge Shaw.
Okay. Division 5, I'm proud to say, is one of the more efficient courts in Jefferson Circuit Court. They do the numbers each month. We're always on one of the top ones. We do that by, when I first started, a judge gave me the advice, any decision is better than no decision. Don't let anything sit, and we do that. We make quick decisions. We do not let things sit and wait. We use all the technology that's available. You've got to remember it's the state. Anything that you want or whatever, you don't necessarily get. But I think the biggest thing since the pandemic has been the use of the phone-in. We now let attorneys, every time I go on record, I have a phone line open, and attorneys are welcome to call in. I've had defendants appear by phone because they're out of state or out of town or whatever, and it is probably the best thing that has happened. We do a lot of civil hearings by Zoom, and I never would have thought that it would have worked, but it works really well, and we intend to keep it. Thank you.
Thank you. Next question will come back to you.
Sure.
What is your vision for Jefferson County Circuit Court system? Will you incorporate the use of digital technology as family court judges have done so effectively?
You know, they've got new technology coming. Division 5 has not gotten the J-Cup system yet. It's all about funding. I'd love to have it. I've been trained on it. I'd love to have it, but their funding just isn't there yet. When we do get it, it'd be wonderful. When attorneys want to have it, and we've got big cases in some of the bigger firms, and it's 2 to 3 weeks, I will ask another courtroom if we can use their courtroom. It's very inconvenient, and some judges aren't too pleased with it, but we have actually held trials in other courtrooms that do have the technology. And like I said, we're on the waiting list, and as soon as we can get it, we'll be up and running. Thank you.
Thank you. Ms. Davis.
Can you repeat the question, please?
Sure. What is your vision for Jefferson County Circuit Court system? Will you incorporate the use of digital technology as family court judges have done so effectively?
Well, I also practice in family court a substantial amount of time, and I actually appreciate and really like the use of the technology. When logging into Zoom, and if you are a host within that, then there are different breakout rooms that you can use. A lot of times when cases are difficult or when you're on different dockets, you're able to jump from one room and conference with an attorney, and then go back to another room and be able to conference with your actual client. I believe that keeps things confidential. It allows for you to expedite things, and then you can let the judges know when you're ready. In addition to that, via Zoom, there is also a link that is there that allows you to upload documents. And when you do that and you upload documents, even if you're in the courtroom, then everyone is able to see the document. Now, I know there are different systems within the judiciary that they say that needs to be updated and things of that nature, but I am also aware that judges can bring in their own technology and that there is a way to upload that and to get that recorded and to get it into the system so that things can be expedited. So I believe that for me, the future of Circuit Court Division 5 would be to be as efficient and effective as possible, to make things as accessible and easy for our civil bar as well as our criminal bar and as well as the litigants. I think that that will take the pressure off, right? It will allow for cost to go down for litigants because they're not paying for travel and unnecessary time and waiting, and it will allow for attorneys to be able to be in the waiting room and working on other things while waiting on a case to be called and not unnecessarily billing. So I think that that's the future, that's where it needs to be, and I am more than willing to work with all of the circuit court judges and family court in implementing those programs. Thank you.
Thank you. This is the final question, and we'll start with you, Ms. Davis. Do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access?
Is that legal help?
To legal help, yes.
Okay. In a perfect world, the answer to that would be yes, but we all know that that's not true, right? I believe that we do what is in the best possible for us to give people access to legal advice. We know that that comes at a cost. We have different programs out there with regard to legal aid. We have different qualifications that will allow for people to be able to have attorneys. There are certain situations where attorneys and court systems are appointed, right? I'm also a guardian ad litem, so judges trust me to represent some of our little people and to be able to protect them, and the state, funds that. But I do believe that there are certain cases and certain situations where I see litigants every day going into court and trying their best to advocate for themselves. They do the best that they can, but obviously they're held to the same standards and the same accountabilities as would be someone who is licensed to practice, has gone through rigorous training and passed the bar. Hopefully, one day in some way that would change. And again, like I said, with using technology, with accessibility, with keeping down on court costs and things of that nature, hopefully that will allow people to be able to afford, right, better legal representation, and so that they too would be able to seek justice.
Thank you. Judge Shaw.
In the criminal field, we appoint PDs when necessary, public defenders. There's a whole set of questions you've got to ask, and you've got to make sure that they qualify. But I never like to see, and I have seen a few, where the defendants are just adamant they want to represent themselves in a criminal, and that's just, I try to convince them that that's not a good ideal, but sometimes you just have to go with what you got, and they want to represent themselves, and we do. In civil, it's really, there's some programs out there for civil people, but it's really not. There's a lot of times that they will be pro se. The standards are a little bit relaxed for pro se litigants, some of the rules, and I try to give as much leave as possible to allow them to be as effective as possible. I always try to encourage them to get an attorney, because it is a minefield to try and represent yourself, but you know, that's their right. So, yes, I mean, you would love for everybody to have the best attorney and the best representation possible, but you know, it's the real world, and that just doesn't occur. Thank you.
Thank you. Thank you both very much.
Thank you.
Thank you.
Yeah, I appreciate it. Judge Shaw and Tracy Davis, thank you.
Hi. Is this one working? Into this one? Oh.
We weren't timing individual questions, just the whole 12 minutes.
Okay.
If they run out of time, they run out of time. But if you want to keep doing it the way you're doing it. Okay. That's fine. Okay, we should probably be consistent since we already got. Okay, thank you. All right, I apologize for that little wait. All right. You guys have the benefit from henceforth hearing the questions. So we will get started, and we will go in alphabetical order, which means, Melissa Bellis, you will be first in your 1-minute introduction.
Thank you. I'm a Louisville native. I graduated from Sacred Heart and Bellarmine and UK Law, where I was published in the Journal. I clerked with Judge Karen Conrad for 5 years, where I gained a unique perspective from behind the bench, and I worked side by side with every facet of a judge's profession. I then started in private practice as a plaintiff attorney in insurance subrogation, and I was the head attorney of the Louisville office for Lerner Sampson Rothfuss in Cincinnati in mortgage litigation and bankruptcy law. As a judge, I will serve with integrity, independence, and impartiality. I was also endorsed by the FOP, as a side note. Given the overcrowding and dangerous conditions in our jail currently and the increase in violent crime, we must prioritize who is sent to jail. Drug abuse, mental illness, these are more medical problems than criminal, depending on the facts of the case. As a judge, I will apply the appropriate law fairly and judiciously, working alongside the police, prosecutors, attorney, and court staff to ensure an equitable, conscientious, and impartial administration of justice.
Thank you. Ted Shouse, 1 minute.
Thank you, ma'am. Good afternoon. My name is Ted Shouse. I'm also a native of Louisville. I live in the house that was on my paper route when I was a boy. I've been a lawyer for 23 years. Most of what I do is represent economically disadvantaged people charged with very serious felony offenses. In those 23 years, I've tried cases from one end of Kentucky to the other. I was also the directing attorney of the Kentucky Innocence Project for a couple of years. I was a public defender for 11 years, and I've been in private practice for 12. I've also been endorsed by most of the labor organizations in Jefferson County. Our teachers stand behind me. A branch of the UAW and the Teamsters and Seafair have also endorsed me. Thank you.
Thank you very much. Our first question, and again, we'll start in alphabetical order, and then the next question you'll start. It has been suggested that prosecutors approve search warrants and that judge shopping be eliminated when the police seek search warrants. Do you support these reforms? Why or why not? And what other reforms are needed?
Oh, I definitely think the reforms are needed. I don't think that a prosecutor should just randomly go to whatever judge is, it sounds like a good judge. I think that they should definitely be random because, otherwise you get the non-transparency. I definitely agree with the randomization of the judge because, 13 judges, you have 13 different people that have 13 different ideas on this topic. So I'm not even sure why they had it like that to begin with, but yes, I'm definitely in favor of that for a variety of reasons.
Thank you. Mr. Shouse.
Thank you. I have advocated for systemic search warrant reform in Jefferson County for over 2 years now. First of all, the judges should be randomized. As it stands now, police officers can pick the judge that they want to take the warrant to. That's the only place in the criminal legal system where a party gets to pick their judge. I'm not aware of any other circumstance in which that's allowed. Second, so that should be randomized, absolutely. The judges should be assigned at random. Second, all the conversations between the police officers and the judges should be recorded. If there's nothing said, then there's nothing to worry about. But if something has been said, that's an important part of the case that the defendant should be made aware of after the warrant has been served. Once the warrant is issued, obviously the tape of that conversation would be sealed and wouldn't be released until after the warrant had been served on the defendant. Third, rejected warrants that judges have looked at and said you don't have probable cause for the issuance of this warrant, those warrants should be placed in a file so that the officer cannot go to another judge and have another judge second guess what the first judge has said. With regard to prosecutors looking at search warrants, that's the way it's done in federal court. I think that's very effective in federal court. The difference is the caseload in federal court is much smaller. There are far fewer search warrants issued in federal court. So that would be an issue for the Commonwealth Attorney's Office to determine if they needed to have on-call prosecutors, but I'm all in favor of that. A prosecutor looking over a search warrant, absolutely before going to see the judge. And I have advocated for those basic reforms for years.
Thank you. Our next question will start with you.
Yes, ma'am.
How would you handle a situation in which a party in your courtroom was being poorly represented by an unprepared or ineffective attorney?
So there's three parts to any case. There's the two lawyers representing the two sides, and then there's the judge. All three of those parts of the process have to be functioning properly within some pretty broad parameters. I mean, the range of what is competent representation is pretty broad. But I think if the judge suspects that one of those parties, one of those lawyers, is somehow impaired, which is sort of implied in your question but not stated outright, or is not providing the most basic level of representation, I think it is appropriate at that point for a judge to stop the proceeding and inquire on what's going on and where we are. I don't think it's appropriate for a litigant to be misrepresented, to be malrepresented in court, and to have a judge simply sit there and watch that go down. I think it's incumbent upon the judge to call time out and to inquire on what's happening here.
Thank you. Ms. Bellows.
Well, I'm going to give the fun answer of it depends, and that's the law school answer, I suppose. But you definitely, depending on the severity of the lack of representation, you have to discuss it with the attorney. I mean, there's not too much the judge can do at the initial stage. Like they were saying earlier, you have to definitely let it play out, and the prosecutor has his job and the defense attorney has their job. In some instances, you might actually have to have a hearing on the case if it's such a obvious malfeasance that you're experiencing. But overall, you do have to address it if it's so serious that it's pretty blatant to the judge and to the court. And you also have to take into the effect the rules of ethics and do your due diligence where appropriate as a judge.
Thank you. Next question, we'll start with you. Mm-hmm. What methods do you have in mind for improving court procedures and efficiency?
Well, COVID has kind of paved the way for that a little bit. We have a lot more remote hearings, remote motion hours, which is great because we can save the trips in the car and the gas prices are up anyway. But translation technology needs improving as well for those who don't speak English. let's see, e-filing motions is a wonderful example of how we could streamline things and make the court system run a little bit smoother. Keep dockets running smoothly. We have to, as mentioned earlier, you would have to decide the cases quickly and efficiently, thoroughly, of course, but definitely keep them on track, keep them rolling, because they'll keep coming in, and you got to keep rolling and getting them out. Phone use in motion hours and hearings is obviously, I mean, we were doing that before COVID, so it's definitely a tool to use effectively. And then Zoom, which we've all been doing during COVID, again, can be an efficient tool. We definitely need to utilize that.
Thank you. Mr. Shouse.
I think what you're going to hear all afternoon is that every cloud has a silver lining, and that one of the silver linings of the pandemic has been the increased use of technology in the courtroom, and I think that has led to increased efficiencies. Obviously, e-filing is here. We've got almost all the civil kinds of cases. I know that's happening again. We're rolling out another branch of that in January. So e-filing, absolutely the way to go. It's been done in federal court for years. It increases efficiency tremendously. Also the use of, as Ms. Bellows said, telephone and Zoom technology. I was in court this morning with an out-of-custody client who has a job. She was able to step away from her job for 12 minutes, 9 minutes, while we got a date for a further proceeding. There's no reason to have litigants come to the courthouse and miss a day of work to come downtown, find a place to park, get into the building, wait, do all that. So obviously Zoom is here to stay on pretrial proceedings. I do think that increases efficiency. It also increases productivity, and I think can be a driving force for relieving jail overcrowding, because as people are released from the jail and have jobs, they can then hold those jobs and still make court appearances. And I think we're going to stop using quotes on appearances pretty quickly, because those are in fact appearances. I know there's a question coming up on visual tech in family court, so I'll speak more about that in a minute.
Great. Well, that's the next question, and it comes back to you. So it's perfect. You'll roll right into it. What is your vision for Jefferson County Circuit Court system? Will you incorporate the use of digital technology as family court judges have done so effectively?
The answer is yes. And while I don't practice in family court, I've checked that out, and I've certainly asked family court practitioners, and I think Jefferson Family Court is leading the way on this technology. Actually, the courtroom I was in this morning also had what feels like a version of that, with a screen in the courtroom for the litigants, the defendants, or the litigants who aren't there in the room to appear on the screen. Absolutely. That increases efficiencies. I would suspect that that'll make the dockets move more quickly, which will allow the court to move the cases more quickly through the system. So I think what we're doing, as I understand what's happening in Jefferson Family Court, sounds like a home run to me, and sounds like it needs to be adopted in circuit court on a regular basis.
Thank you. Ms. Bellows.
Well, it's definitely about time. I clerked with Judge Karem Conrad in Oldham, Henry, and Trumbull counties, and actually they are revamping the Oldham County Courthouse to be a digital court technology hub. So I definitely think that this is something that needs to be implemented. We need more funding for it, obviously. So if I had a magic wand, I'd poof, and then we have the digital technology right there. But it definitely would help trials move more smoothly. You'd get more of a visual effect in all of the proceedings. It would definitely help with trials and make it more easy. Uploading documents for better visual effects and expedites proceedings. It's definitely needed. We have it in family court. We need it in circuit civil.
Great. Thank you. And our last question, we'll start with you, Ms. Bellows. Do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access?
I mean, everyone is afforded a defense attorney. If you can't afford it, then they appoint the public defender. So in that sense, yes. However, it's not a perfect system, and legal aid exists for that reason, I believe. Many times, a pro bono attorney will represent a defendant who just doesn't have the funds. So in that case, they are represented. But like I said, it's not a perfect system. And poverty can be a bar to adequate representation, for sure. So we want to make sure that people are being represented adequately by attorneys. And in some cases, if it's like the earlier question, if you can see that they're not being adequately represented, then it's possible that the court would have to step in at that moment.
Thank you. Mr. Shouse.
The short answer to your question from me is no. There is not equal access to justice. Very often, how much money a litigant has determines their access to justice. On the criminal side, our public defenders and our prosecutors are overwhelmed, and yet they continue to show up every day in our county and do their jobs and do them effectively. On the civil side, there's been a lot of questions in this campaign about what would you do with a pro se litigant. That's because those people can't afford attorneys. Our legal aid society is also overwhelmed. So what can a judge do about that? I would not be in control of the budget of the Commonwealth Attorney's Office or of the County Attorney's Office or the Public Defender's Office. In my practice, my 23 years as a lawyer, my pro bono representation has been some of the most rewarding work I've done. I would begin a program where I would reach out to private members of the bar and meet with them as ethically appropriate and encourage them to take more cases on a pro bono basis. I think we need our bar more active in representing impoverished people, people of limited economic means. And so I would try to do that in Division 7 and encourage, and as a lawyer, I've had judges call me up over my 23 years on the phone and say, can you take this case? I need you to take this case for this reason or that reason. That is incredibly rewarding to me, and I would do that as a judge.
Thank you. Thank you both.
Thank
and
you.
that is Division 7 Circuit Court, Ted Shouse and Melissa Logan Bellows. Thank you very much. Our next division that'll be coming up to talk to us is Circuit Court Division 9. Now, Sarah Clay cannot be with us this evening. She's on extended leave, but we do have her opponent, and we welcomed Nicole Compton up, and in fairness, she will still have 1 minute to introduce herself and 5.5 minutes for questions.
Thank you.
Welcome. 1 minute to introduce yourself.
Good afternoon. My name is Nicole Taylor Compton. I am a Louisville native. I'm the oldest child of 8, born to an electrician and a social worker, and I am a general practitioner. So I've practiced in just about every facet of court that we have in Kentucky, except for Supreme Court, only because I haven't found the right Supreme Court case. But I also practice federally. I do civil, family, as well as criminal. I decided to run because I want to see some changes made in our legal system, and I believe that the best way that I know how at this point in my career is from the bench to effectuate change from the inside out.
Thank you very much. Thank you. And Ms. Compton, your first question is, it has been suggested that prosecutors approve search warrants and that judge shopping be eliminated when the police seek search warrants. Do you support these reforms? Why or why not? And what other forms are needed?
So I do support that reform. And the reason why, litigants cannot forum shop, which means litigants cannot decide that they want to have their case heard in one courtroom over another. It is presumed that all of the judges and all of the courts are equal and adequate. Once you start getting forum shopping, you start getting into indebtedness or the look of impropriety. That is one of the things that is really seems like it's an issue in our court system today, and one of the things that needs to be changed. Then I will say this, it's not the only thing that needs to be fixed, but courts, especially after COVID, have gotten where they are overwhelmed, they're trying to catch up, and it's really easy to just rubber stamp warrants or see every case as a number. One of the things that I would like to do when I am on the bench is to put a stop to that, to make more transparency. I support having a system that would ensure that every person is treated fairly, is treated equally, and there's no, I guess, to restore faith of our community in our justice system. That seems to be one thing lacking, especially in the climate of what's going on in our community in Louisville. And this is the time to rebuild that. This is the time to fix those situations.
Thank you. Your next question. How would you handle a situation in which a party in your courtroom was being poorly represented by an unprepared or ineffective attorney?
Judiciously and carefully. So as a practicing attorney, again, I practice from federal to state courts, district, family, circuit, and have had an opportunity to see various judges handle similar situations. I've watched judges who have pulled the attorneys to the bench, put on the white noise so as to not to embarrass anyone, and kind of have a conversation to get down to the bottom of what exactly is going on. Now, if there is a situation where it seems the attorney who is being ineffective is actually crossing the line of being unethical or something that needs to be reported, as a judge and as an attorney, all the judges are attorneys, so as a judge and an attorney, I've taken an oath, and it would be my responsibility to report that after I've gotten down to to ascertain that that is what indeed is going on. I would be very careful, however, in crossing that line of interfering in the case or overstepping beyond that without consulting an older judge or another judge on how they would handle it, just to make sure that I was doing it correctly, that I wasn't crossing those lines.
Thank you. What methods do you have in mind for improving court procedures and efficiency?
Oh my God. Now, we would be here a long time if I listed all of them, and I like to talk, so I won't list them all. I will give you some. When I became an attorney, I also received my MBA in entrepreneurship. So I'm a business owner and an employer, and I have a background in education and experience with dealing with continuous improvement, with dealing with the actual business of law and how to approve effectiveness and efficiency in processes and systems. So with that experience, I intend to come to the bench in my courtroom and triage where things stand as of today. My goal would be to make sure that litigants or defendants are getting speedy trials, that things aren't just continuously being passed, that when someone comes to my courtroom, I would make sure that the case is progressing, that work is actually being done on the case instead of just continuously giving dates. I would see what cases would benefit from ADR, alternative dispute resolution, such as mediation or arbitration. In those cases, I would welcome ADR to be used in my courtroom instead of seeing it as something that's replacing what a judge would do. It would actually be a tool to benefit making sure that cases are efficiently heard, that the dockets are efficient, and things don't get lost or backlogged.
Thank you. And just a final question, and we only have about 30 seconds left for this one. So do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access?
The answer is no. And there's a lot that can be done. As an attorney, I have continuously found organizations like Legal Aid where I can volunteer. I've done my own programs where I volunteer in the community. Education is going to be a major key in that, transparency and coming together as a community to make that happen. Public defenders are always overworked, underfunded. The legal aid cannot do everything for everybody, but the truth is everyone deserves their chance in court and to be represented adequately.
Wonderful. Thank you very much, Nicole
Thank
Thompson.
you.
And again, she is in Division 9 of Circuit Court, and Sarah Clay could not be with us this evening. Our next division is Division 10. And we have Dorothy Gilbert and Patricia Tisch Morris. Do you prefer Tisch?
Tisch. Yes.
And it'll appear on the ballot as Patricia Tisch Morris?
Yes.
Okay, wonderful. Thank you both for being here.
Thank you.
And again, we will start in alphabetical order with introductions, which means Dorothy Gilbert, you are first, and you have 1 minute to introduce yourself.
Thank you. As a former child abuse and domestic violence prosecutor and advocate, I've had the privilege to do some really important work in my career. In my 20-year legal career, I've learned that many people in both civil and criminal cases, and on both sides of the case, have experienced trauma. When they get to the system, sometimes that trauma is worse. Qualified, knowledgeable, unbiased, and empathetic judges can change that. That's why I'm running. I'm a first-generation and award-winning lawyer with significant, meaningful experience in criminal, civil, trial, and appellate work. I'm a published legal scholar and trainer on topics like trauma-informed advocacy and trial practice. I'm a former director of a pro bono legal program and advocacy program, and I'm the mother of 2 amazing boys who remind me daily how our world can be too quick to judge people wrongly on the basis of their skin color or their perceived abilities. I've received the endorsement of Citizens for Better Judges, and that's the kind of judge I'll be.
Thank you. Tisch Morris?
Yes, thank
1
you.
minute.
Patricia Tisch Morris, and I'm running for Circuit Court Judge Division 10. I am a lifelong citizen of Louisville, born and raised here, Sacred Heart Academy, then U of L undergrad. One thing that sets me apart from a lot of the candidates running, and I think that the bench very much needs now, is that I did actually work and as part of this society before I went to law school. So I have a lot of experience in that regard. And now I have 20 years of litigation experience, a lot of to do on the civil side, but I have touched or practiced in every area of the law that should come before me as a circuit court judge. Not only family law, but probate law, but what is most important, criminal and civil law. I have 20 years of experience in litigation. I have several trials that I've just recently done where I've actually gotten the most significant trial jury verdict for a premises liability case. Again, I think this is an area that is significantly lacking in our judicial system and on the bench, and I am here to change that. Thank you.
Thank you. Now we will again go in alphabetical order, so we will start back with Dorothy Gilbert for your first question. It will be, it has been suggested that prosecutors approve search warrants and that judge shopping be eliminated when the police seek search warrants. Do you support these reforms? Why or why not? And what other reforms are needed?
As some of the other candidates have said, I definitely support the idea that forum shopping would be gone. In my career, I have done work, appellate work, that has helped secure the transparency of the courts, and I believe firmly in that, that the process should be transparent. So I also think recording those proceedings between a judge and a police officer seeking a warrant is a great idea. Should prosecutors approve them? Maybe, but that's not an excuse for a judge to think, oh, well, somebody else has already looked at this and approved it. They must have worked through everything. They must have figured out all of the problems. The primary responsibility is on judges to know the law, to know what equals probable cause, to know what is required for those. And with 15 years criminal justice experience, I know those things.
Thank you. Ms. Morris?
So definitely forum shopping is something that I think is just indicative of what's going on in our system right now, and something that I'm definitely going to change. Forum shopping leads to ties and agendas that are not what is best for our community, and that I'm not tied to anyone that is currently involved in the judicial system in terms of a Commonwealth attorney or a county attorney or a police officer. Although I did get the sheriff's endorsement, I'm not tied to an agenda, I'm tied to the community. So forum shopping to me is something that actually literally goes against everything that we stand for as judges, as being impartial and fair and applying the law equitably among everyone. If I get to forum shop, I get to pick the judge and what they stand for. Well, I stand for what the community stands for, and there shouldn't be that bias going into a legal case.
Thank you. The next question, we'll start with you. How would you handle a situation in which a party in your courtroom was being poorly represented by an unprepared or ineffective attorney?
That is a fine line that judges have to look at. And we are looked at kind of as what you would say, the moderators of a courtroom. So we have definite confines that we cannot cross. However, as previously stated, and again, it's hard to come up with different ideas about what all these other great candidates have said, but when there is something going on, it is our duty and job to the community and to that individual to make sure that they are fairly represented and there's nothing going on beyond the limitations of what we're allowed to. We have actual steps and processes in the appellate court for ineffective assistance of counsel that we can take that measure. But as a judge in my courtroom, I have to make sure that they are not overstepping their boundaries of what I can do and my ethically what I'm bound to do for the community and for that citizen that stands before me. And I have no problem in addressing that, But again, I am within the confines of a judge, so I have to make sure I do not overstep what is limited from my position.
Thank you.
There is no one more impressed with than the judge with the authority and the obligation to ensure that the constitutional rights of criminal defendants, for example, are upheld. When I was a prosecutor, I actually encountered this very sort of circumstance where it was brought to my attention that someone was not being, we thought, adequately represented prior to trial. And I've done tons of work where after trial people are making those accusations. But when you're aware of it or a judge is aware of it before trial, there's absolutely an obligation to inquire, to see what's going on. Because if you wait until after trial, you're potentially waiting until after a conviction where someone's rights were not upheld and they may go to prison while that's being reversed in post-conviction proceedings. So absolutely, a judge has a duty to inquire. One of the other candidates mentioned ethical obligations to report, and certainly that can be something that a judge is required to do, but in the moment, you can't let somebody's constitutional rights be violated.
Thank you. And Ms. Gilbert, we'll start with you with the next one.
Yes, ma'am.
What methods do you have in mind for improving court procedures and efficiencies?
Many of them have already been talked about, as Ms. Morris said, all the other great candidates who've talked about this. Obviously, we've learned a lot using Zoom and phone conferencing. A lot of that was, the phone conferencing especially, was going on in federal court long before we were using it regularly in state court, and that is definitely something that increases efficiency. But some other things that I have in mind are things that I've picked up that I've learned from other judges that I've practiced in front of. So one thing I think is helpful is to set reasonable limits, time limits on hearings, on parts of trials. For example, how long do you get for voir dire? How long do you get for opening statement or closing argument? I also think it's very helpful when a judge is prepared and has reviewed everything before the case. And I've seen judges who are equipped to print orders right there from the bench and to have those entered right there. And I think that's really effective and very helpful in moving things along.
Thank you. Ms. Morris.
Yes, definitely, I agree. There are some things we can do. Preparation is key. Knowledge is key. Before you get on for the day's docket, know your caseload, know what you're working with. That's not always an actual thing that we can do. In a vacuum, it looks perfect, but it's not something that's maybe readily available. But that's why we might have to put in that extra hour or two. But we have to come in on the weekend to make sure our dockets are taken care of. But something that I learned from my father that I think is very effective in terms of making your docket effective and helping the other judges in circuit court. That's walking down that hallway and asking, who needs a trial done today? I'll take it in my court. When I have downtime, I go to the other judges. I can ask them, how can I help you and your docket and move things forward so we can clear up these dockets, people's cases get heard effectively and efficiently, which is key. And this is not only in the criminal arena, which I know this is my opponent where she stands, but in the civil arena, it is imperative too. Those cases often get pushed to the back of the docket. There are so many things we can do with time limits, but also going down and asking other judges for help. That's what we're there for. We can ask what cases should be tried. Who needs to come into our courtroom today? I'll take over that docket. We work for the community. We work for the people. We are paid by your tax dollar. We are there to work. We are there when we have downtime. We help each other out in order to make it more efficient for everyone involved.
Thank you. And the next question, we'll start with you. So what is your vision for the Jefferson County Circuit Court system? Will you incorporate the use of digital technology as family court judges have done so effectively?
So definitely 100% yes. I mean, that's the wave of the future. That's where we're at, right, is technology. We have to accept it. It's coming whether we want it or not, and we can use it to our advantage and still treat people fairly and equitably in the law. So as a civil attorney, we use it quite often. In the last trial I just said, using J-Cup, it's still a slow process, and again, I don't have any control over the budget that we're allowed to use, but I would encourage it because it enables people to attend court without having to miss work, without having to miss family obligations, without having to totally interrupt their lives, and therefore affecting the community at the bottom line. If I can't come because of work or I lose my job, then we've got issues, right? But we've got the technology there. We're not quite up to speed where the family court system is right now. I literally was there not long ago trying a case, and you've got to figure out all the system and how we're doing it with the projection, the TV, and the computer systems. The technology's there. We need to use it. It will come in so much handy for all the people that come before us. Everybody should be get treated in front of me fair and equitably and effectively and efficiently. That's key, and the technology is there to do so.
Thank you. Ms. Gilbert.
Probably around a decade ago, or a little longer than that, I served as part of the Jefferson County Technology and the Courts Committee that ended up bringing Jacob to the courtroom. And so the first cases I tried were using an old-fashioned Elmo and dragging carts through the courtroom, and then to try cases in a courtroom where you didn't have to do that anymore, and you got to push buttons and you got to show exhibits, and witnesses could mark on things right there electronically. It was really exciting. And I think that what we've seen post-COVID is that it's not just with exhibits and it's not just displaying things, but it's other ways that we can increase in efficiency and do things through phone calls and Zoom. And I think this is particularly relevant, as Ms. Morris mentioned, in the civil arena. We'll do less of it as far as trials and those sorts of things in the criminal arena because of the confrontation rights under the Constitution. But in the civil arena, there's many more proceedings that can be conducted remotely in that sort of way. So I definitely think it's here to stay, and we've got to utilize it as much as we can.
Thank you. And the last question, we'll start with you.
Yes, ma'am.
Do you believe that all citizens have adequate access to legal help and the legal system? If not, what could be done to provide wider and better access?
They do not. And I know that from my firsthand experience. Beginning in 2019 until 2021, I was the executive director at the Mary Byron Project, a nonprofit dedicated to enhancing justice to end intimate partner violence. And one of the things that I did there was create a program to provide legal service to survivors of domestic violence, and to create another program to train other lawyers to do that. And that's the kind of things that have to happen. Legal Aid has taken over the program that will train lawyers to do some of that work, and we were doing it in an appellate level and at a trial level. And it's just so important that we have lawyers step in. And when judges who have done that before, as Mr. Shouse said, there are conversations that you can have with other lawyers and say, this is important, this is what you can do, and it's rewarding. And so there's got to be like a media push. And Legal Aid does a wonderful job, but they need more help. So we've got to recruit lawyers to do that, and maybe the Bar Association makes it a requirement.
Thank you. Ms. Morris?
Yes, definitely I do agree with my opponent 100% that people are not fairly and adequately represented. How we can change that are several ways. My husband, who is a big advocate, also a civil attorney, does a lot of pro bono work. He used to be a public defender, so he knows the law in that regard and will go volunteer his time so many times, loves to go and do that, come over to the LBA and utilizes his experiences and his knowledge and his expertise to be a pro bono attorney. That's what we have a huge resource in the civil arena, huge. Attorneys that love to do the criminal work but maybe couldn't afford to do it or couldn't pay the student loan to do it, so they went into a civil arena, and they are just a huge area that we could tap into, and that's something that I would love to, I wouldn't say require, but a lot of the civil big law firms, we can say, here, give us a list of some of your attorneys that we can utilize when we have people that clearly are not fairly represented or don't have representation, or the PD is overwhelmed, or Legal Aid is overwhelmed, which they are. There's just too much and too little and not enough resources, but we have a huge resource to tap into at the civil arena, and I've got that conduit myself in order to do so, to give that representation to everyone fair and equitably.
Thank you very much.
Thank you.
Tisch Morris and Dorothy Gilbert.
Thank you.
And that was Division 10. And while we wait for Division 4 to come up, I do want to remind everyone that the reason why every division is answering the same questions is because the judge divisions are not jurisdictional. You will vote on every single one of the divisions on your ballot. So it's important that each division has an opportunity to talk about these important topics. And with that, we have Division 4. Remember, we saved this one for the last because of the time accommodation. And with us, we have say your last name.
Hegley.
Hagley, thank you.
Thank you.
Ebert Hagley and Julie Kalin. Thank you very much. And we are going in alphabetical order, so Mr. Hagley, you will go first with your 60-second introduction.
Thank you. Good evening. My name's Ebert Hagley. I'm currently a Commonwealth attorney and a proud father of 4. I'm running for judge because the citizens in Jefferson County deserve judges who are going to be hardworking, that follow the law, and have the appropriate temperament to ensure that all people who appear before them are met with dignity and respect. Throughout my career that I've dedicated to public service, first as a county attorney, a Commonwealth attorney, and a special appointed United States attorney, I've demonstrated that I have those skills. That is why I've been overwhelmed with support from my colleagues, from the defense bar, from civil attorneys, and from the Citizens for Better Judges. This community deserves judges that are ready to show up to work and make those important decisions. It's a community I believe in and one I'm raising my family in, and I ask for your vote. Thank you.
Thank you. Julie Kalin, 60 seconds to introduce yourself.
Thank you. Hi, y'all. I am Julie Kalin. I'm currently a district court judge. I was born and raised here in Louisville by a mom who was a teacher and my incredibly hardworking dad, who I'm so glad is here tonight. Both of them taught me through their actions what it means to always be trying to be helpful to people, and I'm so grateful to them for those lessons. I went to law school after having some other jobs, and I thought that what I wanted to do was be a civil lawyer, and I quickly realized upon graduating that that was not for me. I wanted to be in the courtroom. I was lucky enough to be hired on at the Public Defender's Office here in Louisville, where I spent 5 years proudly representing indigent Louisvillians. I had a lot of prosecutors say, my client is the community. I felt mine was too, just one person at a time. After I was a public defender for a while, I knew that I was going to have to do something else if I ever wanted to let my parents stop paying my student loans. So I opened my own law firm. There I did a lot of great work, including expungement clinics. I started 3 of those, and I'm out of time, sorry.
Thank you. No worries. We are going to start again alphabetical order with the first question. So, Mr. Hagley, it has been suggested that prosecutors approve search warrants and that judge shopping be eliminated when the police seek search warrants. Do you support these reforms? Why or why not? And what other reforms are needed?
The easy answer is I absolutely support reforms in our search warrant process. There's clearly a lack of trust in our community with that system that needs to be addressed, because if the community doesn't believe in the work we're doing, it doesn't work. As far as prosecutors reviewing warrants, I don't know, again, that helps. Again, it's hard to come up with different answers than what people have said before, but again, that leads to shortcuts and judges thinking that this has already been approved by somebody. I don't need to look at it as hard. What we do need to eliminate judge shopping is an on-call circuit court judge, just like they have in district court, and we need judges currently approve warrants over email and over the phone. That has to end. I know that that's easy for everybody, but it is an awesome responsibility to ask to sign a document to go into somebody's home and violate the sanctity of their home. And you need to have that person in front of you and to look at them in the eyes and make sure you believe what they're saying. And in instances where it's proven that you were misled or lied to, there needs to be accountability for that as well.
Thank you. Ms. Kalin.
Well, this is actually an issue that has been very important to me throughout my career, and I think I'm the only candidate who's actually proposed real rule changes regarding this. I proposed a rule change in district court that would have ended judge shopping with regards to warrants. They would have had to go to the on-call or the backup judge. It also would have made the entire process more transparent, would have required for the recording of denied search warrants. Those are things that I do anyway. They're not that difficult. I know they can be done because I do them, and I've been doing them while I've been a judge. Unfortunately, that reform did not receive a majority vote from my colleagues, so it didn't go anywhere, but I will plan to continue to push for that. I agree with Ebert regarding prosecutors reviewing warrants. I would hate for that to be seen as, okay, it's okay to sign it. I do think, though, that it is wise often for detectives to have prosecutors review warrants, and I know that they do. One of the greatest honors of my becoming a judge is having had detectives contact me and say, we particularly want you to review this warrant because we know that with your background you will scrutinize it carefully. I always consider that an honor, and I plan to bring those reforms into circuit court with me as well and introduce that reform as soon as I possibly can.
Thank you. Judge Kalin, we'll start with the next question with you. How would you handle a situation in which your party which a party in your courtroom was being poorly represented by an unprepared or ineffective attorney?
Well, if anybody's seen Court Cam, you may have seen this. I have dealt with that many times. I get texts all the time from people saying, I just saw you on Court Cam. I have dealt with this several times. Not all of them go viral, but that one did. Here's the thing. For me, the practice that I did as a public defender and as a criminal defense attorney, the thing that has always been at the front of my mind and that I've carried onto the bench with me is that this is all about the people. This system is here to help people. We're not here for lawyers to make money. We're not here for judges to have jobs. We are here to help the people. And so when I think about the attorneys in my courtroom, I expect them to be prepared. I certainly made sure I was prepared for court always. But perhaps more importantly, I want to make sure that their clients, and it's part of a judge's responsibility, to make sure that their clients know what is going on and what their rights are. And so, you don't want to reach too far into the attorney-client relationship. Trust me, as someone who was an attorney for many years, I'm well aware of that. But I consider it a sacred part of my job to make sure that people are getting the representation that they deserve.
Thank you. Mr. Hagley.
Yes, and absolutely, it's something that I've experienced as a prosecutor, and a judge, like a prosecutor, is in charge of making sure that the proceedings are done fairly and that justice is pursued. And so there is a fine line as far as how involved you get and how early do you get involved. But like many candidates have said, at the end of the day, as judge, it's my name in that building. It's my rulings that are affecting this, and I'm not going to sit back and let anyone's rights be violated. And if that means calling attorneys to the bench, if that means ending proceedings and getting a pass date, whatever needs to be done will be done to ensure that everyone's rights are protected in that courtroom.
Thank you. Our next question, I'll start with you.
Yes.
What methods do you have in mind for improving court procedures and efficiency?
This goes, again, so many of the previous candidates have answered this, but during the pandemic, I was lucky enough in my role, I was in circuit court. I also supervised the rocket docket, which a lot of people might not know what that is, but it's a Commonwealth Attorney Office. It's a group of attorneys that are in district court trying to expedite cases through circuit court. So I would have days where I practiced in federal court, circuit court, and district court. Federal court and district court got on the ball immediately, well, eventually with Zoom court. Unfortunately, only 2 of our circuit courts now use Zoom court on a regular basis. That needs to be something that is instilled in every courtroom. When you make court available to people, whether it be on the phone or by Zoom, it is more efficient. It's people, like Mr. Shouse said, not having to lose their job or take a day off of work and not get that paycheck they desperately need. It's everybody has car trouble. That person doesn't have to miss court and get a bench warrant and then get arrested on that bench warrant and have to take up a valuable spot in our jail until it's all worked out and they're released, because of course everybody has car trouble. So we need to get Zoom court in all courtrooms in circuit court.
Thank you. Judge Kaling.
Well, I certainly agree with that. And again, this is something that I've been doing. When the pandemic started, I was sitting in probate court, which is another area that I have experience in. I've experience in criminal, civil, probate, you name it, I've got it. But I was sitting in probate court and juvenile court at the time, and we received words things were closing down on Friday. By Monday, I was running Zoom court. The other divisions did not move quite so swiftly. We began with Teams, and I kept saying, people don't have Teams. You have to have an Outlook email to run Teams, and we've got to switch to Zoom. It was a long and frustrating process. However, we did get there. And currently, I'm the only judge who uses Zoom with live streaming. I live stream my court every single day. The AOC, which is the Administrative Office of the Courts, has given judges so many tools to work with. But also, I will admit, I'm pretty tech inclined. I was the tech person for the law office that I owned and ran for many years. And so right now, I'm running court in a way where you do not have to come in person unless we are having a hearing or a trial and I've said you have to be there in person. Otherwise, we have a TV on in the courtroom, and anyone in the courtroom can see and hear those on Zoom in real time, and vice versa for those on Zoom. Their view is of who is speaking in the courtroom. All of that is technology that is built in. All of that is technology that I can and do intend to use right away.
Thank you. That'll lead us right into the next question, which is, what is your vision for the Jefferson County Circuit Court system? Will you incorporate the use of digital technology as family court judges have done so efficiently?
Yes, I absolutely will. I don't mind people calling in by phone. You can call in by phone on Zoom. That's fine with me. If there is, let's be clear, circuit court often deals with a little more serious subject matters than district court. So there, I imagine, will be more times where it would be appropriate for a person to be there in person. However, I practiced in circuit court for 15 years before becoming a judge, and I know that there are lots of days where nothing gets done other than a past date. The lawyers may get something done talking to each other, but not much is happening in court. And frankly, I don't want someone there who might already be on the risk of losing their home or transportation or whatever the case may be to be coming downtown just so I can see them. I don't need to see them standing in the courtroom. They can come on Zoom, they can come on my phone. For all I care, the lawyers can agree they don't have to be there at all if it's just being passed. There are things that we can do, and again, for me, it is all about the people of this community and doing what is best for them, making things accessible to people, and making sure that everyone has equal access to be heard in the courtroom, whether victim, defendant, a litigant on a civil case, that everyone who wants to be there and be heard absolutely can and will be treated fairly when they're heard.
Thank you. Mr. Hagley.
Yes, and just briefly, I think it is vital that we update our courtroom systems to have that ability and technology. Budgets are budgets everywhere. I appreciate that, but we are a world that is rapidly changing, and technology that was great yesterday is already outdated tomorrow. And it is important, especially as we have our younger people come and get involved in the court system, and they are expecting all of these accommodations. So I think it is important. I think it's important for the lawyers to have the best opportunity to tell their stories and their clients' stories when they're in front of a jury. I think it's important for transparency and accessibility, and would obviously push to make those as best as they could be.
Thank you. And our final question, Mr. Hagley, do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access?
And again, the simple answer to that is, of course not, no. And that's an unfortunate part of society. But we do, and we are very lucky in Louisville to live in a community that there are so many great programs and so many great people willing to not go out and chase the dollar, willing to go to law school to do something better for the community and to give back. And there are so many of those programs in this community. We are so lucky to have I've been lucky as a prosecutor to deal with a great public defense system. Now the public defenders, like all corporations and jobs, are losing people and not being able to keep up, and caseloads keep getting bigger, and they've reached out, and just a glowing recommendation for our legal community, and former public defenders are taking those cases and coming and doing them for a small fee. We have a great legal aid society. So although we have these great things, of course we should always be looking for ways to do more and to do better.
Thank you. Judge Kalin.
I could not agree more with Mr. Hagley with regards to the quality of our attorneys. Obviously, being an alumni of the Public Defender's Office, I definitely agree with that. Their slogan is "the best legal men's money can't buy," and I certainly agree with that. However, I do not believe that we support them or legal aid attorneys anywhere near at the level that we should with regards to both funding and with regards to making sure that the community is aware of how crucial that funding is. And then deciding how funding is going to be allocated in a way that the community sees the importance of those organizations and those like them. I also have to say, absolutely not is the system open and accessible to all equally. It just isn't, but that is what drives me to do everything that I do. And my goal is to make sure that when someone is in court, that, like I said, that they are heard regardless of what side they are on, but also that we are not just making things worse for them, because I fear quite often that is the case. And I look around and I ask the attorneys, what are we doing? Are we making this better for any of these people, or are we just making it worse? And if we're just making it worse, what are we doing here? Because there's a lot of other stuff we could be doing that could actually help people. And so I think we also need to be looking at an entire reimagining of the system.
Thank you. Thank you both as Division 4 for our circuit court candidates. Thank you very much. And with that, we will be moving on to the Court of Appeals, Division 1, with Audra Jean Eckerly and Tricia Francis Lister. Thank you very much. Thank you, both of you. And just like with the circuit court candidates, we will start alphabetically with an introduction that is 60 seconds. And Audra Jean Eckerly, you will go first with 60 seconds.
Thank you. Thank you for having this forum, and thank you for having us here. I'm Judge Audra Eckerly. I'm currently a judge in circuit court, and I practiced law for 12 years before becoming a judge. In 2004, the citizens elected me as a district court judge. I remained there for 4 years before being elected as a circuit judge, where I remain now. My colleagues on both benches have elected me chief judge. I'm seeking a spot on the Court of Appeals, which is the next level that hears appeals from the circuit court. And so they review the work that I've done for almost 2 decades now. I also, as a circuit judge, hear appeals from the district court, and so I have a lot of experience. I have a nationwide exemplary education, and I also have the temperament to make a good Court of Appeals judge. Thank you.
Thank you. Tricia Francis Lister, 60 seconds.
Good evening, and thank you, LBA, and all the hosts and all the candidates, and thank you to our audience for being engaged voters. Irv Mays is retiring from the Court of Appeals, and I am seeking his open seat. I've been practicing as an attorney in the Court of Appeals for 16 years, and I've been working daily with people throughout the community, and no 2 days are ever the same. Through this work, I have acquired the experience necessary to be an excellent and compassionate appellate judge. My emphasis will be on ensuring that the courts work for everyone. I'm a proud JCPS graduate, as are my 3 children. I attended law school at University of Louisville, and I'm proud to be endorsed by CFAIR, LSURG, and the Political Women's Council. Please take a look at listerforjudge.com to learn more about me, and I would appreciate your vote on November 8th. Thank you.
Thank you. First question, we'll start with Ms. Eckerly. Not all opinions are published from the Court of Appeals. Should they be? Why or why not?
No, I don't think they all should be. I think that the unpublished cases are still accessible, so they're not secret, hidden away somewhere. But a published case should be for when a situation, a fact or law has not been previously addressed by the Court of Appeals or the Supreme Court. If the issues have already been fully discussed, and if there's no problems with the opinions that were already issued, there's no need to publish that and get that out in the community. If, however, something has never been issued before, a ruling has never been issued before, these particular facts are different, the law has changed, something like that, then that absolutely needs to be published. And I think that goes for the Supreme Court as well. It's a useful service, but we don't need to over-publicize everything and then inundate the attorneys and litigants with that.
Thank you. Ms. Lister.
In general, I agree that cases that are just appealed as a matter of right and there's nothing new in them, there's no need to publish those. But as an appellate attorney, I have been frustrated by unpublished cases because I feel like the facts are distinguished enough that it would be helpful, and I do utilize the rule that I can cite the case because it's so on point. I think it would be helpful to practicing attorneys to have more of them published.
Thank you. Our next question, we'll start with you. What can you, as a Court of Appeals judge, do to speed up the appeals process in all cases?
In all cases. It is important to speed up the process for sure, because justice delayed can be justice denied. But on the other hand, justice hurried can be justice denied as well. Due process has to be followed. But what I could do is do my diligence to handle all the cases that come into my office that I'm the lead judge on. Or if I'm on a panel and I'm not the lead, then to read it as quickly as I can and send out my thoughts to get things going. And then I'm sorry, the timer threw me off. I had another thought. Oh, I think also it would be very helpful if we had more staff attorneys. So that's a place that if we really want to speed up the justice process, get more staff attorneys for the appellate judges to help process those cases. So those are my thoughts. Thank you.
Okay. Thank you. Ms. Eckerly.
I think that's the biggest issue with the Court of Appeals currently is the amount of delay and how long it takes to get a written opinion. The Court of Appeals needs to speed things up. Justice delayed is justice denied every time. Now, things don't need to occur at a lightning speed. You need to think about what you're doing as a judge. So for instance, as a circuit judge now, we have 90 days when someone submits a form to issue a written opinion when a case is under submission. So we can do that with our huge dockets. I have over 1,000 cases on my docket currently, a lot more than an appellate judge. So I can get it done in 90 days. In fact, when I started with my division, what I did is I said, I want it done in 30 days. So we've worked hard and we get our opinions out within 30 days. If I have to come in on Saturday and work all day, that's what's going to happen. And the backlog needs to be cleaned out, I think, in the Court of Appeals because it is just taking too long. So something can take a couple of months to decide, maybe a few months to decide, but nothing should ever languish up in the Court of Appeals or in any court for years. The litigants need an outcome. They can appeal from the Court of Appeals to the Supreme Court, so they have another avenue, but as they're just sitting there, and I always wondered as an attorney in my private practice, I submitted that motion 3 months ago. What's going on up there? Well, now I know our dockets are very big, but that needs to be addressed, and we need to be more transparent about why the delays are occurring and work towards correcting them.
Thank you. Our next question, we'll start with you. What skills or qualifications do you have that make you a better candidate for the Court of Appeals than your opponent?
Well, because I'm a judge currently, and the Court of Appeals judges judges. And as I indicated in my opening statement, the circuit court judges from the district court. And I've been there. In my career, I've had hundreds, if not thousands of trials. I've made thousands of rulings. I have not only an extensive criminal background, but I have an extensive civil background as well. So I've tried every case from a breach of contract case to a wrongful death case, medical malpractice in the civil arena, train derailments. In the criminal arena, I've tried everything up to a death penalty case. I've had several death penalty trials. So I think I have the most death penalty trial experience currently of any sitting judge that's even on the bench now. So I have a tremendous amount of experience in the trenches, doing the work, making decisions about objections timely during trials, issuing prompt, thorough opinions now on the bench, and the experience cannot be replaced. It's very important. So I think that some of the best judges we've had on the Court of Appeals have been judges before. I think that's vital. I also told you about my background. I actually served as general counsel for a corporation, and I had an extensive civil practice as well. And I think it is vitally important that we have that kind of experience on the Court of Appeals so that we can ensure that the decisions that they continue to make will be the correct ones.
Thank you. Ms. Lister.
My practice for the past 16 years has been reviewing judges. So I believe as an appellate attorney, I bring the most relevant experience to this position because what I do now is review trials. I watch the tapes, I read the transcripts, I read all the filings, and I decide where the mistakes are and write about those and research the law on those. So I think that is incredibly relevant experience. I bring a fresh new lens to that position with all the work I've been doing in the community and with people in my daily criminal defense practice. So I think that broad lens, tied with my 16 years of reviewing trials and judges' opinions and orders, is exactly what is needed on the Court of Appeals today.
Thank you. Next questions, we'll begin with you. How would you characterize the difference between the trial courts and the appellate courts? In light of those differences, what is the most important experience qualification for an appellate judge, or is trial court experience or appellate experience more important for an appellate judge?
Well, as I was just saying, I believe the most important experience, relevant experience, is appellate experience. A trial court is where that's where the case is being tried, which is sort of a story that is played out for the jury so they can decide what happened and what facts happened and be the fact finders, and that has a very different pace. It all takes place in a particular amount of time, and I've been very involved in that as co-counsel on cases, and in motion practice, writing pretrial motions, setting trial strategies, all of that stuff. But as an appellate attorney, I review all of that. And that's a whole different arena. The case is not being tried there. Nothing new is coming in. It is all about what did happen. I'm going to read that and watch that and see what did happen. So it's a very different mode. And that's a mode that I'm very comfortable with and that I have been practicing in for 16 years now.
Thank you. Judge Eckerly.
Circuit courts and all trial courts and courts of appeals are very different animals indeed. So in circuit court, it's the trials and the hearings, they're about a search for the truth. That's what we're doing, especially when we have a jury. That's what they're trying to find out. What's the right answer is a search for the truth. When you get to the Court of Appeals, however, what they're doing is looking for error. They're reviewing, so it's completely opposite in that respect. They're reviewing the things that the trial court judge did and seeing if any of those were erroneous. So it's a completely different job. But I feel differently than my opponent on this issue. I think you have more experience in that when you've actually done the job that you're reviewing. I think that is critical. And I ran out of time on my last answer, but I also wanted, since I've got some more time on this one, I also wanted to point out my educational background. I went to Sacred Heart here and for high school, and then I went to the University of California at Davis. I graduated summa cum laude. I spent my junior year in France. I speak fluent French. I went to the University of California at Berkeley for law school, which is consistently ranked in the top 5 law schools in the nation. So I have a tremendous educational background. I clerked for a federal judge, which is a tremendous honor my first year out. So I bring that to the table as well. And I also have almost all of the endorsements in my race.
Thank you. Our final question, I'll start with you. What can appellate judges do to make the appeals process more accessible and understandable to the parties and the public? Unlike trial court records, appellate records are not available online. Should it be a priority to make electronic access available?
I think so. I'm all in favor of transparency and accessibility. We've worked hard in the circuit court to make forms available for pro se litigants. I think there needs to be more work done on the appellate level for that. I also think that technology plays a role in accessibility. I think it's difficult. I know it's difficult for the Court of Appeals to sometimes hear what happens in jury selection because the microphones aren't in the back of the courtroom, and so technology needs to be upgraded so that it's very clear what is happening. The video record also needs to be updated. We have a lot of needs in the technology arena, and until you have the appropriate technology, you don't have the appropriate accessibility. And I think the Courts of Appeals needs to do a lot of work in that regard. I also think regarding the delays, more transparency needs to occur. We need to know, is there a person responsible for that? Is there a process? What can we do? And I mentioned earlier that I served as chief judge of both district and circuit because as an appellate judge, you don't make decisions by yourself. You make them as a group of 3. And so I'm a team builder and a consensus builder, and hopefully I'll be able to persuade my colleagues, if I'm successful in my quest for the Court of Appeals, to make things more transparent and to speed them up quite a bit. Thank you.
Thank you. Ms. Lister.
I would say about the question that federal appellate practice happens all online, and that the technology is there, and that makes it a lot easier as a practitioner, and we should definitely be making that happen here. I would like to now back up and also point out that I got a fabulous education at the Brown School, and U of L is not ranked in the top 10, I'm sure, but it is a local school that I got a very good education in, and I booked the legal writing class, so writing is my thing. And I am prepared to review the trials and write appellate opinions about it. And I also just think my broad life experience in this community will be an incredible asset on that court. Thank
Great.
you.
Thank you both. Again, that's a Court of Appeals Division 1 with Audrey G. Eckerly and Tricia Francis Lister. Next, we have Court of Appeals Division 2 with Mackenzie Cantrell and Annette Karem. Thank you both for being here. And again, we will start in alphabetical order with 1 minute to introduce yourself. And we will start with Mackenzie Cantrell. 60 seconds.
Hi, everyone. My name is Mackenzie Cantrell, and I'm a candidate for the Kentucky Court of Appeals. I've been an attorney for 10 years, actually, this week. And in those 10 years, I have crammed in as much diverse experience as you can imagine. I'm a graduate of U of L Law School. I'm a proud Beachmont resident in the South End. My first year outside of law school, I represented employment litigants in private practice, and after that, I took my skills that I gathered in private practice and combined that with my passion for representing low-income and immigrant clients. And for the past 9 years, I've represented individuals in employment law actions for Kentucky Equal Justice Center. For the past 6 years, the South End of Louisville has given me the honor of a lifetime in being their state representative and serving in the Kentucky House of Representatives. And for the past 2 years, I have taught as an adjunct professor at U of L Law School. So I have practiced law, I have made the law, and I've taught the law. And now I want to be your appellate court judge.
Thank you.
All right, good afternoon. I'm Chief Judge Annette Karem, and I've been a lawyer for 25 years. 4 of those years were in private practice, where I was a litigator. I was an advocate in trials. I wrote briefs for circuit court. I wrote briefs in federal court. I wrote appellate briefs. I even argued at the Sixth Circuit and won. Just want to put that in there. I then went on to spend 7 years with the Jefferson County Attorney's Office as a domestic violence prosecutor, and then 16 years as your district court judge, and now the chief district court judge. I'm very proud of my endorsements with the pipe fitters, with the FOP, and with the deputies. And that one, I just want to point out, those are the people, the deputies are the people that see me every single day, both as a prosecutor and as a judge. And so over all those years, they felt that it was important for me to remain on the bench. So thank you. I ask for your vote.
Thank you. Now, our first question, we'll start with Ms. Cantrell. Not all opinions are published from the Court of Appeals. Should they be? Why or why not?
I don't think that necessarily all opinions should be published. However, as a practitioner, it is so frustrating to find a case that perfectly matches your case's facts and perfectly matches the law that is challenged, and feel like you have to jump through hoops in order to use that decision because it is unpublished. There is, I think, a good distinction between published and unpublished opinions, because unpublished opinions are more an appeal of right that just needed to be decided and is not necessarily deciding a new area of law, and a published case might be. But we have to strike a better balance and help practitioners out there use their case that they want to use because they've done the work to find it, and not make them jump through a bunch of hoops in order to use it, and have more respect for their use of case law.
Thank you. Judge Karem.
So no, I don't believe that everything should be published. I think absolutes are probably not the best thing in the world. No, they shouldn't all be published, but it is important to publish good cases. And we need to look at the criteria, which would be, is it important to the bench? Is it important to the bar? Does it instruct the lawyers, or does it instruct the judges on how to practice and be better at what they do? Is it a case of first impression? Is this something that's never been seen before in court? And is it something that's really important to be heard and used at another date? So yes, it's absolutely important to give that instruction and allow cases to be used at a later time, but I think we need to be judicious with that decision.
Thank you. Our next question, we'll start with you. What can you, as a Court of Appeals judge, do to speed up the appeals process in all cases?
So I think probably the most common complaint that we've heard on the campaign trail is that it is slow. And I recently went to an education session to learn more about the Court of Appeals, because that's where I want to be. And I learned a great deal about the fact that there's a lot of times that cases are delayed, not just by judges that may be a little slow in what they're doing, but also by lots of motions that might be made by attorneys. And I don't know if there's a way to make sure that there are not frivolous motions made, and to ensure that everybody gets their case heard in a timely manner, because every case has a face behind it, and it's important to remember that and to move those cases along. So for what I can do, I will make sure that I have I love to write, I love to research, and I love to write. So I'm going to do it expeditiously and judiciously.
Thank you. Ms. Cantrell.
So there's nothing more frustrating than waiting for a case for a ruling to come down from a court. I had a situation recently where in the span of time it took for a judge to decide my opinion, the case drastically changed because the party's ability to pay a judgment drastically changed. So I certainly understand the frustration there. But there's also a frustration, at the Court of Appeals. What's different than some of the other judges that you've heard from is we hear cases in 3-judge panels. So I don't know if any of you have worked on a group project, but writing an opinion with 3 other judges and getting a consensus on that is very hard, and it's you're going to utilize a different set of skills than maybe you have in other work, and that's probably where I think a lot of the sort of obstacles come up in terms of time. I mean, people get sick, people go on vacation, and it's hard to get together to meet. But one thing I can pledge is that I work really well with people, I meet deadlines, and am going to be encouraging a lot of camaraderie on the court in order to get things done, because that's what we are charged to do as judges, is to get things done for the public.
Thank you. Now our next question, I'll start with you. What skills or qualifications do you have that make you a better candidate for the Court of Appeals than your opponent?
So I talked about this a second ago in the previous answer, working on a 3-judge panel. So some of the other judges that you've heard from, they're kind of on an island because they're running their own courtroom and they're making their own policies and procedures. But I've been in the legislature where I can't do anything on my own, and you have to build relationships. So that's what I've become really good at, is working with people who are a lot different than me, who believe things differently than me, who maybe want to do things differently than me, and meeting them where they are and saying, well, how can we get this done? How can we work better? People expect us to accomplish these things. How can we do them together? And that's where I think I bring a really unique set of skills to the Court of Appeals, because I've been doing that work already and have been working well with others and want to do that on behalf of the people of Kentucky.
Thank you. Judge Karem.
Sure. So as far as working with other judges, I'm the chief judge of district court, and there's 17 of us. It's like herding cats sometimes. I love every one of them, and we are all thoughtful, intelligent human beings, and we all have different opinions. So, as far as that's concerned, I have that. I've had that experience for the last almost 2 years. And that's what matters in this: experience, 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 and that's what sets me apart. As a litigator, in private practice, I litigated trials, and then as a judge, I've had trials. And I've written appellate briefs in private practice, and I argued in front of the Sixth Circuit, and I have that experience that's important. It's specifically important this year because this is the term where all 3 of our appellate judges are retiring. That means there's going to be, a lack of experience up there, maybe. And so I think everybody needs to remember that I have the experience. I've been a judge for 16 years. I've had trials. I've had hundreds of trials, and that's what matters. And so that's why I'm asking for everyone's vote.
Thank you. Our next question, we'll start with you. How would you characterize the difference between the trial courts and the appellate courts? In light of those differences, what is the most important experience or qualification for an appellate judge, or trial court experience or appellate experience more important than an appellate judge?
So in the best of circumstances, you have a judge at the appellate level that has both, and I'm that candidate. I've had both. I was a litigator. I tried cases, won and lost them, and I'm a judge now, and that's what matters, both of those things. Experience will dictate how the job is going to be done, and you can just look back and see how I have presented myself. I have the temperament. I've worked with other judges, and I can make sure to get the job done, but they both matter, and experience at this level matters the most.
Thank you. Ms. Cantrell.
I think if I had to put it in terms of one word in what the Court of Appeals means, it's diversity. Because you are hearing cases from all over the state. You're hearing cases from maybe a circuit court case that resulted in a civil trial, multi-million-dollar verdict, a criminal trial, maybe a custody appeal from one of our family courts. And you have to be ready to, do a little bit of everything. And that's what I've done as a state representative. One minute we're fighting over the transportation budget, and then the next year you're making very serious decisions over teacher pensions or criminal law or something like that. And you have to be really nimble to work through all of those things. And I have a really broad understanding of the law because of my time in the state legislature, and I think that's going to be a real asset. And it's not just those hard skills of working with the law, it's kind of those soft skills of being a member of a statewide body already. So I understand and have been to most parts of our state in my service in the legislature. I understand those communities, I understand their needs, and I think I'm going to have a better understanding of the cases that originate from their part of the state on the Court of Appeals.
Thank you. And our final question, we'll start with you. What can appellate judges do to make the appeals process more accessible and understandable to the parties and the public? Unlike trial court records, appellate court records are not available online. Should it be a priority to make electronic access available?
So e-filing is going to be a part of the future of the appellate courts, and that's already in the works. So I think one of the important things about what we're going to be charged as new judges is overseeing, when a system rolls out like that, there's going to be some bugs. Hopefully there's not as many bugs in that system as there are in our campaign finance system, KREF. I know a lot of us have dealt with those issues lately. And so that's going to be a really important part of making our court system more transparent. And I'm not going to take credit for that. That's already in the works. But you've heard from some of the other candidates today about Zoom court, and I think the more technology that's available in our court system is a lot better. For example, if I wanted to conference with another judge in another part of the state that we were writing an opinion on, that's a great way to do that face-to-face. However, you have to balance that with transparency in the courtroom, and I'm really sympathetic to transparency, because in the state legislature, our committee meetings and floor proceedings and a lot of what we do is on camera. And I think I think people know more about me as a state representative because of that, because I've had to be on camera all the time. And we've seen recently that KET has been brought into the Supreme Court room for their oral arguments. And I think an arrangement like that to make our middle appellate court system more transparent, on camera, and being accountable to the community is a great start.
Thank you. Judge Karem.
I think transparency is of utmost importance. In district court, we're on the record all the time, constantly being recorded. Court Watch joins us on Zoom. Oftentimes I have someone on Court Watch that is watching court to see what we're doing and how we're effectuating justice. And I think that that's important at the Court of Appeals. I think everyone needs to know what we're doing as judges and whether we're truly working for you. And so transparency is very important. Of course, technology is what's made the transparency we have in the district court available. And that's what we need to do in the Court of Appeals level as well. There's no reason we can't move this technology into that level of court system. So,
thank you. Thank you both very much. Again, this is Court of Appeals Division 2.
Thank you all.
Mackenzie Cantrell and Judge Annette Karem. Thank you so much. And our final division of the evening is actually the Kentucky Supreme Court. So I welcome both Angela McCormick-Bizik and Jason Bowman. Thank you very much for coming up, and I appreciate everybody listening. And just to remind you that the reason it's so important to listen to what the candidates have to say is because judicial races are nonpartisan, so you cannot rely on party lines when you step up to the polls. Welcome, and thank you both for being here. And we will go in alphabetical order. Oh man, we got these. I got to sit here and do my. No, I'm just kidding. That would be. Our first 60 seconds will go to Angela McCormick-Bizik. Thank you.
Thank you, Ms. Feldkamp.
Thank you.
Good afternoon to everyone here. You all get gold stars for good citizenship for lasting this long. I always say, my name is Angela Bissig. I'm running for the Kentucky Supreme Court. I always say judicial races aren't as interesting to hear candidates speak because instead of talking about issues and plans and what we're going to do, we tend to talk about ourselves. And that's because what we bring to the table is the role of justice. I've been a judge for 20 years in our community, both in the district and the circuit courts. In this election for the Kentucky Supreme Court, I'm happy to say I've had support from plaintiffs' lawyers and defense lawyers and from prosecutors and lawyers who represent criminal defendants. And that's because I hope I'm someone, if you ask a lawyer in this community, you know that I will be prepared for your case. You know I will treat everyone involved, lawyers and litigants, with respect and dignity as part of the process. And I hope I can have your support for the Supreme Court.
Thank you. Jason Bowman, 1 minute.
Good afternoon. I'm Jason Bowman, and I am your candidate for the Kentucky Supreme Court. I want to thank you for allowing me to speak here today, and I want to thank everyone who put this together, because it's not often you get to see candidates in these positions side by side, that voters get to see this and make their decision on November 8th. I'm the unique choice for the Kentucky Supreme Court because of my active and continual practice of service and at law allows me to bring a unique perspective to this. It's my passion over 18 years of practicing the law, of serving individuals and families and representing them in courts, trial and appellate courts. You combine that with my service as a veteran, as a city council member, as a business owner, as on community boards and charities. It's this approach, combining those, that allows me to take a unique perspective and voice that we need on the Kentucky Supreme Court. Louisville is my city, Kentucky is my home, and I am your candidate for Supreme Court.
Thank you. Our first question will start with you, Judge Bissig. Personal rights that have traditionally been perceived as being protected by the U.S. Constitution are increasingly being governed by state constitutions. As a justice of the Kentucky Supreme Court, what do you see as your role in protecting personal liberties pursuant to our state constitution?
Sure. Anyone who is a student of the courts right now, normally those of us running for judge spend a lot of time just explaining why judicial races matter. If you're watching what's going on in our country right now, there's been some change in our United States Supreme Court. A number of the decisions that have been rendered show us that issues that affect us all, involving everything from healthcare to employment to pandemic rules, are going to be coming back to state court levels. So it's important that we have judges who are familiar with the law, who know the rule of law, who have had experience applying it, who can be a strong voice. The question was about protecting people's constitutional rights. That is the alpha and the omega of being a judge. We can all agree, no matter what our political ideals are, that those founding documents, our Constitution, our Bill of Rights, are the things that protect us all. They are the things that allow us to have a fair society. You know, if we don't know there's somewhere we can go if we have a dispute, or we have a neutral arbiter to hear that dispute, or if our laws are violated, that there's a judge who's going to apply the law with compassion when that's necessary, or with a stern fist when that's necessary. That's where our society has its foundation. All of the other things like healthcare and jobs and all the other things we talk about in politics are difficult if we don't have a society that believes their justice system is fair.
Thank you. Mr. Bowman.
Thank you. I do think it's very important as we look at, especially at this race, and as the federal government is starting to shift powers back to states. We're trying to put that more back in the states' hands. That's where the advantage of having these nonpartisan judicial races come into play. Part of the reason that we may be here now is because we have partisan appointmentship on the federal courts. Well, luckily, we don't have lifetime appointments here either. And so it is important as we elect our officials and elect people to our Supreme Court and to our Court of Appeals and even our trial judges, that we're keeping in mind that these are important issues that we're going to be faced with. And that evaluating our state constitution, evaluating the laws that our legislatures have passed, and evaluating the cases as they come up through the system I've seen firsthand, just by my practice in 18 years, what good laws can do for people, but I've also seen what bad laws do to people. And that's really why it's important that we protect those rights of individuals.
Thank you. Mr. Bowman, the next question will start with you. What qualifications do you have that make you a better fit for the Supreme Court than your opponent?
I think the biggest advantage that I have is actually the 18 years of active and continuing practice in the trial courts and to the appellate courts. Is because as an active practitioner of this, you don't have the luxury of sitting back and hoping that the law comes to you. You have to be active and continually learning on the law. In the past 10 years, our legislature has passed over 1,800 laws. In the past 10 years, our Supreme Court of Kentucky has rendered 1,800 decisions. Every Friday at 10 o'clock, I'm pulling up the Court of Appeals minutes and I'm seeing the decisions that are rendered. Every month, I'm seeing what was rendered by the Kentucky Supreme Court. I follow the House bills, I follow the laws, I stay on top of the laws, the rules, because that helps me serve my clients better. And by serving my clients better, hopefully we can avoid going to the appellate courts. But if we have to go, then knowing the law and actively practicing the law is a huge benefit.
Thank you. Judge Bissek.
What I bring to the table, and I respect my opponent and everyone here that's running for the bench, but what I bring to the table to this job is not only 20 years in being a judge and doing the kinds of things I'll be reviewing for error as a Supreme Court judge. I've been elected twice by the Louisville Bar as the Judge of the Year in 2013 and 2020, by the Kentucky Justice Association, also by the American Board of Trial Attorneys. So I bring judicial experience. I've also worked on numerous boards of directors in this community, the Dare to Care Food Bank, the Center for Women and Families, the Volunteers of America, the World Affairs Council, and I say that because I want to have the balance, not only to have a career in the law. I was a civil lawyer and a prosecutor before I was first elected to the bench, but also working in the community, because you need to meet people, you need to understand the issues that are important to people. It gives you that seasoning and that ability when you're judging credibility, when you're looking at people in your courtroom, to have, as I said earlier, compassion for those that need help and need services, and to be tough with individuals who need to be held accountable for things that happen. I think I can bring both of those to our Supreme Court. I'll also say that strong writing skills are very important at that level. I wouldn't be a trial judge any longer. I'm someone who served as articles editor for Law Review back when I was in law school. My note was published and chosen by my peers, and I think if you ask lawyers who receive my written work now, they would tell you that it's thorough, it's organized, and it's on point.
Thank you. Our next question will start with you. What are your plans to help the public understand the role of the courts in our system of governance?
So, you know, Alexander Hamilton said, the first duty of society is justice. And I think it is important, it's very important that the public understand the civics, and it's not, I think the public is smart, educated, and we're all doing our best. But it's hard when this is the quiet branch of government. In a three-cameral system, we are an equal check and balance. And I think Sandra Day O'Connor, who was appointed by Ronald Reagan, made it clear that the framers of our Constitution thought it very important to have an independent judiciary in the way our government works. And I do think it's important both to educate the public about what we do. Things like bail reform and things like search warrants that you've heard the other candidates talk about. Part of it is just educating. What is the process? What laws are applied? What things are judges considering? And then secondly, understanding that I don't want to be beholden to any group that I have campaigned and told you I will rule the way you need me to rule. Because I feel like as someone prepared to follow the rule of law, I need to be able to look at the facts of any given case and look at the law as I understand it and apply it in a way. There have been some beautiful opinions written both in our state Supreme Court and our federal Supreme Court that you can tell that justice understood the community would be reading those and the community needed to have confidence in those. I am ready to bring all that to our Kentucky Supreme Court.
Thank you. Mr. Bowman?
I think the big issue to kind of piggyback on that is when we say that our community understands that and our community is going to read that, is that for too long, I think that especially our appellate courts, that community is the lawyers we're writing to. You're the ones that are most likely going to read it, and so I'm going to write to you because you're the one that's going to use that, and it doesn't appeal to the public at large. In fact, the public, most of the time, aren't going to hear about an opinion or what's going on in the Supreme Court unless it's reported by the media. And then that will be their only access if there is a post or a link there to even pull up the opinion or the brief that has been filed in that matter. So in order to make, I believe, that the public has more accessibility and understanding of what's happening or how the system works, is trying to develop that transparency, communication, and by that, education. So that way, as we get into people's individual liberties, that they're not walking into the court and saying, I don't understand why this is happening. Because most people don't think about the court system unless they're in it. And that's not a bad thing, that you don't have to worry about it unless you're involved in it. But it is important that I think that people understand what's happening in the court system. Because without that, what you really do is you are lacking that information. That causes confusion and then ultimately causes distrust in the entire system.
Thank you. Next question, I'll start with you. How can litigation costs be reduced?
That's the hard part. The biggest thing that I think can reduce litigation costs is speeding the process up in the best way possible. I agree that the courts are overworked. I think they are understaffed. But as someone who's actively practiced in 18 years and seeing your clients that you ask for a trial date and you get a trial date that's 8 months out. You have a trial and then it takes 6 months to get an opinion out of the court. And then, okay, we want to appeal that, so then suddenly it takes a while. And the courts have shown that they can have the speed. Even in the recent Planned Parenthood, it was 120 days before oral arguments are scheduled to be had. An opinion will probably come out in less than 130 days. Whereas I had a custody case, it took 292 days. A termination of parental rights, it took 292 days for me to get the Court of Appeal to vacate, which they did, and reverse the trial court. That's almost a year where my client didn't get to see her child. And in that time, during that year, that 292 days, which would have been important for direction to the courts, approximately 2,000 children had their parents' rights were terminated to those children. So the direction to the courts of, hey, this is the law, you must follow this, is very important, because that, even 292 days doesn't sound a lot, but that's a lot of people that are affected by the delay.
Thank you. Judge Bissig.
I'd like to talk about a couple of things I'm working on right now that I think that address the issue you just raised. One, I am one of 2 current circuit court judges who work on what we're calling a business court pilot project. Businesses in our community inevitably have disputes over contracts and other issues. The goal of the business court, and we have, we've talked about all the benefits of technology. It also gives you this unending realm of discovery. You can get into policy and procedure manuals from 20 years ago. So the goals of the business court docket that I work on are a pilot to look at streamlining the discovery process, fast-tracking a case to get into mediation and then trial, always having a next follow-up date, and having the judge have a conference at the outset so that they know the key issues that need to be determined to resolve that dispute, and the judge can get the discovery focused to save time and money. And I think the rules that were not written by me, they were written by a community of people that some of them may be in here, could maybe be used in our regular civil litigation to some extent. I have also worked on for years bringing restorative justice to the criminal side. Restorative justice is trying to make victims whole. Part of what we do when we enforce criminal laws is to serve victims, to make victims whole, but also to do things for offenders that may cause synapses to connect that would make them not want to reoffend. So being tough on crime by stopping crime helps get rid of a backlog in court. So those are 2 things I'm working on currently to address the issue you just raised.
Thank you. And our last question, we also asked this to the Court of Appeals, but we would like to know what your thoughts are. Not all opinions are published. Should they be? Why or why not? That starts with you.
That's such a good question. I think Judge Karem went through the general list of what you look to. Opinions are published, obviously, if there's some new area of the law, especially at the Supreme Court level. There's not going to be any higher level of review. That's the law of the state. But we've all of us who've practiced in the law have been frustrated by a lack of Kentucky case law on issues that we need to argue that come before us. So more published opinions would result in more Kentucky case law that we can rely upon. I think there are some brilliant people on our current Supreme Court, and I'm not. But if you look at the Kentucky Supreme Court and statistics about where it's cited around the country in terms of its jurisprudence, in terms of its decision-making, it's in one of the lowest. And one of the things I want to do, if I'm able to get there, is to work with all of my colleagues and talk about ways the Kentucky Supreme Court can both be a mentor to the court system, but also kind of up our game in terms of our jurisprudence and what we do to make Kentucky what I know we can be from living here in Louisville and from meeting with my colleagues out in the state in terms of someone you can look to for legal reasoning and legal decisions.
Great, thank you. Mr. Bowman.
I do think that we are underpublished when it comes to our appellate decisions. And I say that because I think that's almost a complacency in my default position is it's unpublished. And then we've got to convince ourselves that why does this need to be published? But you find the areas of law, specifically, I mean, family courts are 20 years old. They were established 20 years ago. And while we have appellate decisions that are published that control certain issues, there's a lot of issues that aren't published. And it's continually unpublished, which makes it very difficult when you go back to court and you're arguing with the court and trying to convince them their position, and all you can do is cite that, hey, this isn't binding precedent to you, but this is very similar, and this is what you're dealing with. It also makes it very difficult as a practitioner when you're advising your clients as to what the ultimate outcome could be. And you have an idea of what the Court of Appeals may do or the Supreme Court, but it's not binding precedent, so we don't really give people, by a lack of publishing, we're not giving people some predictability in what the law is or what the law is going to be interpreted as. And so by publishing, or at least making a more rational thought of, does this benefit this state to publish this opinion, and making that active decision from the appellate standpoint, then you're always going to have that, guessing game when it comes to what the status of the law is.
Great. Thank you both. Again, this is Kentucky Supreme Court candidates Angela McCormick-Bissick and Jason Bowman. And that is our last division for the evening. And I want to really thank everyone for coming out. And I just want to remind everyone that every single division, every judicial seat is on the ballot in November. And it is not jurisdictional. You will vote for someone in every division. And there's a lot of excitement over the national level and the Supreme Court, the national level. But if you are arrested here in Kentucky, it is one of these individuals who is going to help you, who is going to carry you through. So it's important that you do your homework. And you will find the judicial guide on the Courier-Journal.com with questions in writing and in video form to help you make those intelligent decisions, so you know when you end up in court, whether it's your worst day of your life or not, that you can trust the people in front of you to carry you through. Thank you so much for being here tonight, and to the Louisville Bar Association for hosting us. Good night, everyone.